Hello everyone, welcome to StudyIQ IAS English channel. My name is Shubham Sagar. Today we have to talk about this particular issue, RTI Act destroyed, and why 30 odd activists are fighting to restore the original sanctity of RTI Act. See, there are two words here which we have to understand from exam perspective or from, even from like UPSC perspective, non-UPSC perspective or general awareness perspective. Two words are, first is dilution, second is destruction. First phrase is dilution of RTI Act, second phrase is destruction of RTI Act. And then there are 2 years, 2019, something happened which many people, many scholars believe led to extreme dilution of RTI Act. What happened in 2019? If you know it, you can post it in the comment section. Otherwise, I will tell you. Second thing which is happening right now in 2025, many people feel like now it's almost the complete destruction of RTI Act. We have to understand these things. At the same time, there is another act, one act which is linked to this RTI Act, which will be destroying, so to say, in quote, the RTI Act. What is that one act? We have to talk about that as well. There are so many things involved here: right to privacy, KS Puttaswamy judgment, and DPDP Act. We'll talk about it. So, March 24, 2025, Hindu page number 11. Congress calls for repeal of Amendment to Data Protection Act. We are, with due respect to all the political parties involved, we are not concerned with any political party. And if you read this article, you will realize that activists have ferociously pushed back against that argument. Again, we'll see. We are more concerned with what is the general rationale behind opposition to whatever amendment is happening in this particular act, DPDP Act, which will be impacting RTI Act. So here, we have to see DPDP Act as well. There are certain terms: data principle, data fiduciary, right to be forgotten, very important, and right to privacy, KS Puttaswamy judgment. Questions have, UPSC has already asked a PYQ on that. Now there is one question for you. If you know it, you can post it in the comment section. What is a constitutional bench of Supreme Court? When we say that constitutional bench has given the verdict that right to privacy is a fundamental right, what do we mean by the term constitutional bench? If you know it, you can post it in the comment section. Very good. Now let's talk about this particular news. So there is an amendment which has been proposed in this DPDP Act. We'll talk about it, which will take away whatever is left in RTI. What does that mean? I will tell you. So, Congress leader again, he has called on Union Minister Ashwini Vaishnav to repeal an amendment that weakens the RTI Act 2005, which has already been weakened a lot after an amendment in 2019, which took away so-called security of tenure of information commissioners and chief information commissioners. What was that particular thing which happened in 2019? We'll talk about it. Key concern, the amendment which has been proposed to, or which has been passed to digital protection. Again, let's come back to this. Digital protection, data or Digital Personal Data Protection Act to 2023, that is DPDP. What this particular amendment is, it restricts the disclosure of personal information, effectively undermine RTI Act. See, there is a section in RTI Act, and that particular section is, you can see it here, section 8 clause 1 subclause J, where it says that if there is a matter of larger public interest, then personal information will also be revealed. Sometimes you may have heard about that there was one particular government official, he was supposed to be involved with a foreign spy of Pakistani origin, etc., etc. This is a personal information. So RTI says, and section 8 clause 1 subclause J of RTI says that if there is an matter of larger public interest, personal information will be revealed. Now, citing right to privacy under KS Puttaswamy judgment, which led to passage of this act, Digital Personal Data Protection Act, DPDP Act, government is saying that, and government has introduced a provision that no, we will not reveal any personal information. Doesn't matter whether it is a matter of larger public interest or what, under RTI will not reveal it. So, in a way, people say that this particular amendment which has been introduced in DPDP Act will kill this section, which is of immense importance when it comes to RTI Act, section 8 clause 1 subclause J. Keep it in mind. Okay, sir. So now let's talk about DPDP Act. There are certain terms which you have to understand because UPSC has already asked a PYQ on right to privacy, KS Puttaswamy judgment. So Digital Personal Data Protection Act is a law enacted in India to regulate how, again, you can see, understand one thing. We have data on Facebook, Instagram, and people these days use Snapchat and whatnot. And sometimes you may have heard elder people telling you, beta or beti or son or daughter, please be very mindful rather when you are sharing information. And sometimes you will be like angry or sad or not so interested in social media, you will deactivate your Facebook account and this and that, or sometimes delete. You may feel like you have deleted your Facebook account, the information is gone. The reality is much more complex. You are not forgotten, and that's why information still persists somewhere or the other inside the Facebook domain. That was the issue, and that's why this particular act was introduced, that I have a right to be forgotten. This is my data and I am a data principal. Users are called data principal. Who will be collecting your data? They are data fiduciaries. So you have to understand these words, data principal, data fiduciaries. That is a tongue twister. Who they are, and we have a right to be forgotten. All these things are reinstated or stated by DPDP Act, which is actually good. But whether killing or undermining RTI Act is good under the disguise of DPDP Act, that is a question we have to ponder upon, and you have to answer in the comments section. Okay, so now DPDP Act, consent management. Here, pay attention to these words. What are data principal under DPDP Act? Data fiduciaries. So users have the right to withdraw consent at any time, that I don't want my information on Instagram, and here data fiduciaries who are collecting, they can be organization inside India and outside India. It applies to both of them. So they must ensure transparency, security and compliance. If I want my information on Instagram, it has to be removed from Instagram or Facebook or something else. So that is what DPDP Act strives to do, which is very noble. But again, as we have discussed, using DPDP Act to do something with RTI Act, whether that is noble or not, we have to think about it. So again, let's come back. Exemptions. Again, government is exempted. If they want, they can take any data, personal data. Those things DPDP Act does not apply to them. So government agencies are exempted from some provision of the Act in cases of national security, law enforcement or research. So government agencies, you can see here, they have a lot of power, and if they want to search your personal history, they can search it. You cannot use DPDP Act. And again, in some scenarios, not in all scenarios. Let's come back, bros. RTI diluted, RTI destroyed. These two are two different things. We have to understand them one by one. 2019, something happened. What happened? RTI Amendment Act 2019 changed the tenure and salary structure of Chief Information Commissioner and Information Commissioner, CIC and SICs. What happened there? So earlier there is a term which you may have heard a lot: security of tenure. Supreme Court judges, etc. They have a security of tenure. They'll be there for a certain number of years, or 65 or whatever is their retirement year, and they have salary predetermined. And that similar kind of provisions were there earlier for Chief Information Commissioners, State Information Commissioners. Then in 2019, so much protest happened against this particular amendment. Government decided that your tenure, earlier the tenure was 5 years or 65, whatever comes earlier for Information Commissioners. And the salary was also similar to Chief Justice of India or something like that. Supreme Court or Chief Justice, I'm saying, the judges of Supreme Court, salary will be similar to that. So these were some of the provisions, not exactly in the same manner, but hope you're understanding. It was already predetermined. What this particular amendment did, I will show you the provision. What this particular amendment did, everything based on what will be your tenure, what will be your salary, all these things will be determined by central government. Understand one thing. And like when we are filing RTI, whom are we filing RTI against? More often than not, we are filing RTI against government. So if information commissioners, their tenure, their salary will be decided by government, how transparent will they be? Or will they allowed to be? Don't you think we are in a way just removing that particular security of tenure? We are compromising the whole RTI structure. Please understand these. These provisions are fine, but please try to understand what was there before 2019 and what happened after 2019. Before amendment, CIC, Chief Information Commissioner, had a fixed tenure of 5 years or 65, whatever comes early. Their salary was equivalent to Chief Election Commissioners, not even Supreme Court Judge or CIC. I take those words back. CC and election commissioners, but all these things were done away with. All these things earlier provided so-called security of tenure to Chief Information Commissioners and other commissioners. Now what is the scenario after the amendment? Union government, most of the RTIs are filed against union or state governments, and now they have the authority to determine the tenure. It's not fixed like 5 or 65, and salary and terms of services of CICs and SICs through executive rules. This undermines the independence of information commissioners, making them vulnerable to government influence. That's why we are saying RTI has been diluted to a great deal. Do you agree? Like, what is your view about this 2019 amendment? Do you support these amendments which happened in 2019, where their salary, tenure, everything was, is based on the whims and fancies of central government? Do you agree with this thing? Do you think it has undermined RTI to a greater extent, or you feel like, no sir, it's fine? RTI is still very independent authority, and it has, like, it has not been diluted. So information commissioners now lack financial and administrative independence. Salary will be decided by central government, tenure will be decided by central government. How can they think about doing something or revealing information against central government? That is the thing which we have to think upon. Government control over their salary. Again, you can read these things. Critics argue that this change discourages commissioners from taking bold decisions against government agencies, and that's how we have, sir and ma'am, diluted RTI. Yes or no? Now let's come back to the present article. Let's try to see how RTI is now being destroyed. It has already been diluted. Now it has been, there are attempts made to destroy it or dilute it further. So civil society opposition. Again, DPDP Act, they're trying to dilute or do away with the section 8 clause 1 subclause J of RTI Act, and 30 civil society organizations. It's not just about the opposition. These organizations, civil society organizations, they're like, no dude, transparency and accountability will go out of the window because you want to promote privacy. Privacy is fine, and we have to have a debate regarding this privacy versus transparency. But are we destroying RTI by doing away with or trying to do away with section 8 clause 1 subclause J of RTI Act via an amendment in DPDP Act 2023? So pending notification. Currently we can still, and there is a room for public opposition because it is in the draft phase. It is not yet being implemented. So we are talking about it and we should talk about it. Ashwini Vaishnav sir is saying that right to privacy judgment, K.S. Puttaswamy judgment has already, diminished the relevance of section 8 clause 1 subclause J. Please remember this of RTI Act. Then civil society says that no sir, the RTI Act, they have maintained a perfect balance. That particular section 8 clause 1 subclause J maintains a perfect balance between privacy and transparency. It's not like always we want the personal data. It's for larger public interest, and it has beautifully maintained the balance. Now you are trying to disrupt that balance by introducing this particular amendment in DPDP Act. So activist response. Activists disagree, maintaining that RTI Act originally struck a careful balance. That's what we are discussing here. Public disclosure. Vaishnav claims that personal information required to be proactively disclosed under other laws will still be made available. So if there are some other laws, let's say, Official Secrets Act, will not go there. If there are some other laws which talks about revealing personal information, we will do that. Then the activists say that sir, the biggest law which talks about revealing personal information, if needed, is RTI, and you are diluting that only. So Ramesh appeal. Jairam Ramesh, again Congress leader, he has formally urged the government to pause, review and reveal section 44 clause 3 of DPDP Act to protect RTI's core principles. Diluted. RTI Act has been diluted via that amendment of 2019. Do you want to destroy it? What is your view about all these 2019 amendment and the current things which are going on? Do you believe RTI has been destroyed, or do you think no sir? No sir, no sir, RTI is still awesome. It is working awesome. I have filed an RTI. I got perfect response. I'm very happy with it, satisfied with it. Whatever is your view, you can post it. And you can also post the answer of this particular question in the comment section. Consider the following statement regarding RTI Act 2005. There are 3 statements given here. Which of the statement given above is or are correct? A, B, C, D. You can see 1 and 2, 2 and 3, 1 and 3, 1, 2 and 3. Whatever is your answer, please post it in the comment section. And please, sir and ma'am, for the sake of, transparency in our government setup, answer this question. Whether RTI Act has been destroyed, or do you think there is still something which is left in RTI Act, or there's still some hope, and we should not be losing hope, and RTI is working perfectly fine. Whatever is your view, please post it in the comment section, and I will share this particular PDF along with the answer of the objective question I just asked you in this Telegram group of mine, that is Fun Study with Shubh, because study should be fun. Okay. And yes, if you are preparing for 2026, or there is a friend or colleague or son or daughter of yours who is preparing for 2026 UPSC, CSE, and they can join our March morning batch. Batch is starting on, like from today, 24th March, and it includes prelims and mains residential program. If you are a monthly topper, you will get 11,000 reward, full refund if you clear UPSC prelims 2026, and there is interview guidance program included in this particular batch, because this is P2I, prelims to interview. And you can use my code which you are seeing in the bottom section, SHS Live, to get maximum discount, sir and ma'am. So that's it from me. What is your view? Is like there is anything like, do we still need to like have hope, all means pinged on RTI, or do you think, sir, RTI is gone, RTI is diluted, RTI is destroyed? Whatever you feel, do post it in the comment section. Take care, be blessed. I will see you soon.